Ladies and gentlemen, welcome to the last webinar session of Kohler Group's webinar series on Hong Kong versus Singapore. Today's topic is Battle of the Asian Jurisdictions, analyzing what is the better jurisdiction, Hong Kong or Singapore. I'm very pleased to have two members of Kohler Group's team, Pierre Carguet and Dennis Dussler, who is going to be competing one against the other in terms of what is the better jurisdiction. Before we begin today's presentation, I would just like to make sure that we're not incurring any technical difficulties. If all the attendees would be so kind as to click on the hand button in the control panel, that will allow me to know that the sound system is functioning. As is typical with our webinar series, we will have a Q&A session at the end of today's presentation. So don't be shy. Please add your questions and comments into the question section of the control panel. It's always nice at each webinar session to see new faces. So for those of you that are not familiar with who we are, please allow me to introduce our firm. Kohler Group is a subsidiary of CSC, the corporation service company, which is headquartered in Delaware, the United States. Kohler Group has three offices within 3 jurisdictions in Asia, Hong Kong, Singapore, and 8 offices within mainland China. We assist foreign investors with their market entry, pre-investment advisory, and all corporate compliance, legal compliance, and tax compliance functions that occur once an entity is established, plus human resource services. We have a team of over 120 professionals that are located throughout the 10 offices within the region. And our unique advantage is that we do speak over 11 languages and have international desks catering to clients throughout the world. A little bit about myself. My name is Christina Kohler-Coluccia. I'm a director at Kohler Group, and I will be the moderator for today's session. I've been working with the firm since 2003 when I opened our first office in China, primarily in Shanghai, and expanded our operations to 8 offices into China. I've been helping foreign investors with their market entry and expansion within the China region, but also within the Asian region, primarily Hong Kong and Singapore. I'm co-author of our monthly magazine, ChinaInvest.biz, which highlights all the latest trends and regulations that are occurring within the region. And if you're interested in subscribing to it, it can be easily done so on our website by simply inserting your email address in the section called ChinaInvest.biz. So without further ado, I will give the microphone to Dennis and Pierre, who will initially just introduce themselves, and we will then begin with the presentation today. Dennis, Pierre.
Okay, thank you, Christina. Hello, everyone, and thank you very much for attending this presentation today. This is Pierre speaking. I'm senior consultant at Kohler Group, and I'm in charge of the French desk. I'm sitting here with my colleague Dennis.
Yeah, welcome and hello everyone. Thank you for joining our presentation today. I'm Dennis Dussler. I am representing the German desk in Hong Kong, and will also represent Hong Kong today.
Right. So Dennis and I, we are both working at Kohler Group's business advisory department. The particularity of this department is our ability to serve our customers in their own language and advise them on questions related to their existing or future investments in the Asia-Pacific region. So in today's presentation, we would like to confront Hong Kong and Singapore from an incorporation, compliance, and immigration point of view. It is sometimes hard for investors to assess which jurisdiction to choose, as they are very similar in many aspects. The goal of this presentation is to share information and opinions on which jurisdictions seems better at the moment for each category that we listed out. Next slide, please. So these categories are, well, after a quick warm-up, we'll go to the first one with incorporation and bank account opening. Then we'll go to review accounts and audit regime. Then we'll review the annual compliance obligations. And afterwards, the immigration policies. And finally, the options available for exiting the market. And we will conclude with general recommendations. Next slide, please. So if you take a look at the table, you can, on the left-hand side table, you can already see, observe some similarities. There are 7.2 million inhabitants in Hong Kong, 5.4 million in Singapore. Hong Kong has a one-third larger area than Singapore, and both city-states have signed a double taxation agreement with China. And they are the two main places where offshore renminbi is accessible. Hong Kong and Singapore are also ranked as the freest economies in the world, at respectively the first and second place. This ranking is basically listing the jurisdiction where it's fairly easy to set up and run a business. If you now take a look at the map, Singapore is right in the middle of the so-called Indonesia, Malaysia, Thailand growth triangle, whereas from Hong Kong you may access more easily mainland China, Taiwan, Korea, or Japan. Next slide, please.
Yeah, as you can see from the headline of this slide, we are now transitioning into the battle part of this webinar. However, for this slide, we will still literally be on the same page. And here we will compare the corporate and local requirements to incorporate a company in Hong Kong and Singapore. Taking a look at the table, we can easily see that the requirements are very similar. Both jurisdictions require a company to have at least one shareholder and one director. Whereas a shareholder can be a corporate entity as well as a natural person, the first director in both jurisdictions has to be a natural person. A company can only be added as an additional director afterwards. For both jurisdictions, they do not allow the issuance of bearer shares, meaning that the transparency is very high who is owning the company in the end. For both jurisdictions. The minimum paid up capital is $1 Hong Kong or $1 Singapore dollar respectively. However, that being said, there are major advantages to having a higher paid up capital, for example in terms of bank account opening. The registered office is permitted, meaning that you do not have to maintain a real physical office in the jurisdiction, which significantly reduces the operating costs. Additionally, there is the mandatory position of the company secretary each company in the two jurisdictions has to maintain, as it acts as an intermediary point of contact between the company and the government authorities. However, this position does not have to be paid, a paid employee, as corporate service providers like Köhler Group, for example, can take this position as a corporate service provider, as a company secretary for your firm. Generally speaking, at the time frame for incorporation, we are looking at 1 to 2 working days for both jurisdictions when using e-registration. And finally, the final point I've not mentioned yet is the local resident director, which is a Singapore-specific requirement. So my colleague Pierre will tell you more.
Right. So the local resident director in Singapore can be a Singapore citizen. It can be a Singaporean permanent resident, an employment pass, or a dependent pass holder. Therefore, you will be eligible to act as local resident director of your company as long as you hold either of these documents. Corporate services firms like Köhler Group can offer solutions combining the registration of a new company, the provision of a temporary local resident director, and the application for an employment pass or an entrepreneur pass, for instance. Next slide, please.
Okay, going into the second part of this first round, we'll be talking about the corporate bank accounts for your company in either jurisdiction. And starting off with Hong Kong, you need a registered Hong Kong company before you can apply with the banks for a corporate bank account. And the minimum documents that you would have to present are, apart from the corporate documents of the company, of course, the passports and address proof for each director and natural shareholder. For corporate shareholders, a certificate of incorporation, memorandum and articles of association, and an excerpt from the company's registry showing the shareholders and directors of the parent company are necessary. All documents, including the address proof for individual shareholders, have to be translated into English if you are from a country where English is not the first language. Additionally, the banks usually do not start their due diligence until they've met all directors and shareholders holding more than 10% of the equity personally in Hong Kong. The timeline in Hong Kong we're looking at for bank account opening ranges from 2 to 8 weeks, depending on the case and the bank. It's very case specific. And generally speaking, because it's about bank accounts, and I'm assuming most of today's listeners will probably be aware of the current issues surrounding bank account openings in Hong Kong, as banks have increased their compliance and news everywhere that bank account openings have become impossible. And I want to clearly state here that while it has gotten more complicated, it is by no means impossible. The banks still assess each case individually and on a case-by-case basis, and if you're unsure about your possibilities of getting an account for your company, I would recommend you to get in touch with a professional service provider like us, and we can give you an outlook and a realistic estimation. Some of our recommendations you can already see here in the bottom of the slide, like a high turnover and substance in Hong Kong, for example. And yeah, next slide, please.
Okay, so moving forward on opening up a bank account in Singapore. So once you have successfully registered your Singapore company, you can go and apply for bank account opening. As one of the major international financial places, Singapore, of course, offers numerous options for banks and other financial institutions. That said, you may choose your bank taking into account some important criteria. For instance, you may consider whether to choose a local or a foreign bank. If you are planning to control your company from overseas, choosing an international bank with a strong network overseas would be the best option, because you can go to the branch overseas, and obviously you can execute whatever transactions you have to do since you're on the same time zone. Then the other criteria would be assessing the level of services that the bank is offering. Some banks can offer immediately credit card services or trade finance services, and some do not provide this kind of service. So you may also inquire the bank in terms of what kind of supporting services they can offer you. And then the last important criteria that you need to take into account is that, well, most of the banks today, they're required to meet at least one director or a bank signatory. That said, you need to know in advance and understand exactly who needs to come to Singapore or who do not need to come, and what is the level of supporting documents that are required for the individuals or the companies involved as director, shareholder, or beneficial owner. So that would be also a very important question to assess. Generally speaking, the time frame for bank account opening depends on the bank you want to work with. Same as for Hong Kong, Singapore banks have to perform extensive due diligence prior to onboarding a customer. Therefore, you can consider a minimum of 3 weeks to get your accounts opened. Next slide, please.
Yeah, going into the conclusion for round 1, we will have a results page for every round, by the way, to give you an idea in between who we think is more advantageous. For the first round, in our opinion, it ends in a draw. We reason this with the very similar requirements, where Hong Kong has an advantage in the incorporation and maintenance of a company, where no local resident director is necessary. And Singapore currently is ahead when it comes to bank account openings, as the banks are less complicated than in Hong Kong. Next slide, please. Okay, the second round of the battle will be around the accounting and audit regimes in each of the two jurisdictions. Starting off with Hong Kong again, the requirements are relatively low, while the quality, due to compliance with the international financial reporting standards, is high and easily consolidable with other jurisdictions' accounting systems. The financial year can be freely chosen in Hong Kong, and this can be quite helpful as Hong Kong subsidiaries can adopt the financial year of the parent companies and therefore reduce the complications for the consolidation of accounts even further. And the audit of the head office overseas can also be consolidated easily. However, all Hong Kong companies, irrespective of the size and turnover, have to audit their financial statements annually and submit the audit together with a profit tax return to the Inland Revenue Department for assessment of the profit tax, which especially for smaller businesses can be a factor to consider. Additionally, as Pierre stated earlier, Hong Kong is the largest renminbi offshore center in the world, so Hong Kong is in a privileged position to actually be able to get money out of mainland China, which is for many businesses a reason in itself to establish a Hong Kong company to add, for example, to a Chinese WFOE. Next slide, please.
Okay, moving forward, so the Singapore Financial Reporting Standards, which is the SFRS, is aligned with the International Standard of Accounting, which means that standard bookkeeping documents such as the P&L, the balance sheet, the cash flow statements should be prepared. Singapore companies should file management accounts every year. That being said, you should consider not only the statutory requirement but also the volume of transactions which are to be booked. The more transactions are to be booked and the more it is advised to maintain accounts on a quarterly or on a monthly basis. Of course, this principle is applicable for for Hong Kong as well as for Singapore. In addition, it should be noted that the Singapore Financial Reporting Standards offers a greater level of flexibility for small entities. The SFRS for small entities is a simplified version of the full SFRS, which aims to make the accounting requirements less complex for smaller companies. For example, the reporting standard for small companies exclude topics and disclosure requirements that are irrelevant to the typical SME. Excluded topic includes earning per share, interim financial reporting, insurance contracts, segment reporting, and asset held for sale. All of these are excluded. The objective is obviously to reduce the compliance costs for small entities. A Singapore incorporated company or a Singapore branch of a foreign company is eligible to apply for the reporting standard for small entities, provided that it is not publicly accountable. It publishes general purpose financial statements for external users, and it is a small entity. An entity qualifies as a small entity if it meets at least two of the three following criteria. These criteria are the total revenue should not exceed 10 million of Singapore dollar, the total gross assets should not exceed 10 million Singapore dollar, and the total number of employees should be no more than 50. Moving forward on this slide, another interesting component of the Singapore accounting system is the accounts filing in XBRL. XBRL stands for Extensible Business Reporting Language, and it is a language that aims to facilitate the transmission as well as the treatment of business and financial data worldwide. In other words, this is a data coding standard allowing programs to easily identify, extract, and compare them. There are various levels of XBRL requirements depending on the legal form of the company or the activity of this company. Next slide, please. So regarding the audits, every company registered in Singapore should appoint an auditor within the 3 months following their incorporation. A big difference with Hong Kong is the possibility that you have that qualifying companies have to be exempted of audits. So I listed here again the requirements that a company should satisfy in order to get the audit exemption, and they are the same requirement as those for getting for being qualified for the accounting reporting for small entities. So again, the total annual revenue for the financial year should not exceed 10 million Singapore dollar. The total assets for the financial year should not exceed 10 million Singapore dollar, and the company should have no more than 50 employees. Again, for a company which is part of the group, the company must qualify as small entity, and the entire group, which the company is part of it, must be a small group to qualify to the audit exemption. For a group to be a small group, it must meet at least 2 of the 3 quantitative criteria on a consolidated basis for the immediate past 2 years consecutive financial years. Next slide, please. So Singapore presents obviously a greater level of flexibility for SMEs than Hong Kong, and therefore, well, Singapore is winning this one. Next slide, please.
Going into round 3, we will be discussing the tax regime for both jurisdictions, again starting off with Hong Kong. The tax regime in Hong Kong can be seen as one of the biggest benefits to incorporating here. Firstly, the corporate tax rate at 16.5% is among the lowest in the world in a developed and mature market. And the tax rate is also at a flat rate, so no matter how much profits you make, you will be taxed at 16.5% and never more. Income derived from non-incorporated entities, meaning, for example, partnerships, income derived from real estate, such as rental income from tenants, if you have the luxury to rent out parts of your office, are taxed at a 15% flat tax rate. There is no value-added tax or capital gains tax in Hong Kong, so essentially it is attractive also for dividend payouts, since they're legally tax-free from the company's perspective. And additionally, there is also no withholding tax on dividends or interest gains from the Hong Kong side. However, royalties are taxed at the 16.5% normal rate, unless there is a DTA between Hong Kong and the country you're selling royalty rights to, in which case the withholding tax can go as low as 4.95%. That being said, withholding taxes are always a matter between 2 jurisdictions, so in general we would advise you to check also from the other side. So if you're, for example, dealing with a trade between the US and Hong Kong, definitely also check from the US side. Much like in the UK, there's also a stamp duty in Hong Kong at 0.2% of the sales price or value of the movable object sold or rented, whichever is higher. And this applies, for example, to real estate, including rental income and share transfers. Finally, for the corporate side, it is possible to apply for corporate offshore tax exemption in Hong Kong, reducing the profit tax from 6.5% to 0%. If all profits are not derived from or in any connection to Hong Kong. This has to be applied for with the Inland Revenue Department and is assessed on a case-by-case basis. An important distinction here, if you, for example, have 20% of your profits from offshore business and 80% are derived directly in Hong Kong, you will not get an exemption on the 20%. You can only apply this for your entire profits. In the bottom of the slide here, you can see some of our recommendations to follow when you want to ensure the success of your offshore tax exemption application. Basically, the main criteria is to not have any substance here in Hong Kong so that you can really prove that your profits are offshore nature. Next slide, please. Okay, moving to the taxation of individuals in Hong Kong. The taxation is, unlike for corporations, progressive. So on the first Hong Kong dollar 40,000, you will be taxed at a rate of 2%. On the next 40,000 Hong Kong dollar, you will be taxed at 7%. Actually your effective tax rate at an annual income of 80,000 Hong Kong dollar would be 3,600 Hong Kong dollars, and so forth. So anything above an income of 160,000 Hong Kong dollars annually is then taxed on the remainder tax rate of 17%. Different from many European countries, for example, the tax is not deducted at source. So you will only be taxed once a year on your entire annual income instead of having the taxes directly deducted from your paycheck. Also, Hong Kong has a great advantage in terms of allowances. If you give your employee a housing allowance, it will only be taxed at 10% of the value, no matter how much the allowance is. This means you can effectively reduce your taxes this way when you, for example, have a salary of 2 million Hong Kong dollars and rent an apartment at an annual cost of 1 million Hong Kong dollars as an example. You can let the company pay your housing allowance over the 1 million Hong Kong dollars, and the tax on that portion would only be taxed at 10%, meaning 100,000 Hong Kong dollars instead of the remainder tax rate of 17% for 170,000 Hong Kong dollars. Additionally, there is no tax in Hong Kong on a personal level for dividends received or generally capital gains, as well as on income derived from overseas businesses. Next slide, please.
Okay, let's go to the Singapore tax system. So the profit tax rate in Singapore is 17%. The VAT equivalent, which is called the Goods and Service Tax, GST, is at 7%. In terms of passive income, dividends are not taxable, interests are not taxable for residents and taxed at 15% for non-residents, unless the rate is reduced under a domestic exemption or a treaty. And royalties are not taxable for residents and taxed at 10% for non-residents, unless the rate is reduced under a domestic exemption or a tax treaty. Unlike Hong Kong, Singapore does not offer the possibility to apply for tax exemption on offshore profits remitted to Singapore. Having said that, the Singapore Tax Ordinance also states that foreign-sourced income received in Singapore is tax exempt. Question is, how does the Inland Revenue Authority of Singapore, the IRAS, interpret the wording received? Well, the tax department clarified this question and explained that foreign income is taxable in Singapore as long as funds are coming to Singapore, so they are remitted to a bank account in Singapore. Foreign income is used to settle debt due to a Singaporean third party. And foreign income is used to purchase any movable property that is brought to Singapore. So in other words, that means that if you accrue income overseas, and let's say that your Singapore company has a bank account overseas, if the income is accrued on this overseas bank account but is never brought to Singapore, then according to the tax ordinance, your company may be tax exempted on these funds. The particularity of Singapore, when compared to Hong Kong, stands with the tax incentives that are offered to attract startup companies. For instance, if you take a look at the first table on this slide, a newly incorporated company may not be taxed on its first 100,000 Singapore dollar income during its first 3 years of activity. Referring now to the second table, after 3 years, company can still enjoy a tax rebate on their first 300,000 Singapore dollar income, with the tax lowered to 8.5%. In addition to that, Singapore will also offer a one-time tax rebate to Singapore companies until 2017, which is a tax deduction capped at 20,000 Singapore dollars. And it is likely that the tax rebate will be renewed after 2017. Another great tax incentive available for Singapore companies is named PIC scheme. PIC stands for Productivity and Innovation Scheme. And under this scheme, businesses which have invested in one or more of the 6 qualifying activities can claim up to 400% of the qualifying expenditure as tax deduction, or they can claim a cash payout of 40% of the qualifying expenditure with a cap at 100,000 Singapore dollar. So either deduction, a tax deduction, or a cash payout. There are 6 qualifying expenditures. Briefly, there is acquiring and leasing information technology and automation equipment, training employee, acquisition and licensing of intellectual property rights, registration of intellectual properties, research and development activities, and design projects. If you need more information about these qualifying expenditures, then feel free to contact us afterwards, and we'll be happy to reply your inquiry. So as the PIC scheme aims to encourage entrepreneurs to invest and develop their business, it is likely that it will be extended after 2018, which is the current deadline for this scheme. Next slide, please. All right. So going now to the individual tax system, same as in Hong Kong, individual income is taxed at a progressive tax rate from 0 to 22%, as you can see on the table. The good news is that foreign source income as well as capital gain are not taxable in Singapore. Director's fee as well as consultants' fees are taxed at a flat rate of 20%. In addition, if you are an employee of a Singapore company but you do not reside in Singapore on a permanent basis, then you may consider that staying less than 60 days will allow you to be tax exempted, whereas staying more than 60 days but less than 183 days will attract a flat rate of 15%. Lastly, it should be noted that any incentive or benefit granted to the employee is subject to income tax as per the Singapore tax ordinance. Next slide, please.
Yeah, considering all points, the tax regime of Hong Kong comes out on top. The possibilities to apply for tax exemption is very favorable for companies that do not derive any profit from Hong Kong itself. And even when a company pays profit tax, they pay 0.5% less than in Singapore. And additionally, there's no VAT or GST in Hong Kong. And the average individual tax rate for the higher income segments, which is the majority of foreigners seconded to these locations, is lower as well. Next slide, please. In round 4, we will be discussing other annual obligations for both jurisdictions that are necessary to maintain a company. The annual obligations for a Hong Kong company, apart from the audit and tax filings, are very simple and mostly are not even considered by most companies venturing into Hong Kong. First and foremost, each company has to maintain a valid business registration certificate. As these are always renewed on an annual basis, it will have to be renewed prior to each anniversary of the company. The company's registry takes a marginal fee for this, which even has been lowered in 2016 from 2,250 Hong Kong dollars to 250 Hong Kong dollars. And then there is the annual return, which is an annual notice to the company's registry stating who the company secretary is, who the directors and shareholders of the company are, where the registered office is located, and which auditor was employed for the audit in that financial year. Important to note for both the business registration and the annual return is that both can result in penalties if not submitted too late, up to date, So you want to make sure that you have a trusted company secretary in Hong Kong that can take care of these documents for you. Lastly, there is the annual general meeting, which is split into the annual general meeting for shareholders and the annual general meeting for directors, which are documents where the respective directors and shareholders have to sign off the year and confirm the financial results of the company in the respective year. Next slide, please.
Okay, moving on Singapore, I've listed here the other main annual obligations for Singapore companies. So filing the annual general meeting is one of these obligations. It is not mandatory for directors to come in person to Singapore to file this AGM. However, they should ensure that the accounts presented at the AGM haven't been prepared later than 6 months prior to the AGM date. The time elapsed between each AGM shouldn't be superior to 15 months. Another obligation is filing the ECI, which stands for Estimated Chargeable Income. This procedure is to be made directly with the Inland Revenue Department of Singapore within 3 months after the financial year ends is issued. A company with no income should still file annual return, so that still remains an obligation. Then we go to the third annual obligation, which is the GST return. So as mentioned earlier, the GST stands for Goods and Service Tax and is a VAT equivalent in Singapore. 7% tax is levied on the supply of goods and services in Singapore and the import of goods into Singapore. Filing GST works on a voluntary basis for companies with a turnover up to 1 million Singapore dollar per year. Conversely, if a company's turnover is superior to 1 million Singapore dollar, then filing quarterly GST return becomes mandatory. Lastly, we have the annual return filing, which is the fourth main obligation. So it has to be filed with both the company's registry of Singapore, the ACRA, within a month after filing the AGM, and it also has to be filed with the tax department, IRAS, by November 30th every year. Next slide, please.
For round 4, we chose Hong Kong as the winner by a very small margin due to not having to file the estimated chargeable income and the GST return mainly. So the obligations are a little bit less. Next slide, please. Round number 5 will be all about immigration. Starting off with Hong Kong, I want to preface this by saying that I will only go through the immigration options concerning relocating professionals, while there are still other visa options, for example, training or study visas. Generally speaking, when you enter Hong Kong as a tourist, you will receive a visa on arrival. If you are holding the passport of a Western European or North American country, you're very likely to enjoy up to 90 days of practically visa-free entry and visa-free stay, which is very advantageous when you want to explore the market before investing into Hong Kong. And the most common visa for foreign professionals in Hong Kong is the employment visa. You have to have a signed employment contract with a local company and at least a bachelor's degree, while the company has to prove its financial stability by providing an audit of either the Hong Kong company or the parent company. Against common belief, mainland Chinese applicants actually have a much harder time obtaining this visa than professionals from, say, the US or Canada, and often have to go through the mainland professionals and talent scheme, proving they have an exceptional background that is not found locally. An alternative option for entrepreneurs or investors is the investment visa, for which investment over at least 10 million Hong Kong dollars in recognized local areas is necessary, and also the applicant has to be able to support himself without having to rely on a return from this investment. The dependent visa is the last one I'm going to discuss here, is for spouses of other visa class holders. The dependent visa allows taking up employment if the spouse under the visa is also permitted employment. So basically all of the, or not all of the above, but employment visa and investment visa holders, spouses under a dependent visa are allowed to take up employment. Finally, if you stay in Hong Kong for 7 consecutive years under any of the mentioned visa classes that allow employment, you will be eligible for permanent residency, enabling you to stay in Hong Kong and work in Hong Kong for the rest of your life. Next slide, please.
Okay, immigration in Singapore. I listed on this slide the main visa schemes available in the city-state. So I'd like to highlight two of these schemes which are more relevant for future expatriates and investors. So let's go first to the employment pass, which is the main type of work permit for company owners or skilled employees who will be working in Singapore. There are a few requirements to apply to the employment pass. First, the employee should be sponsored by a Singapore company. Second, the employee who is applying should hold at least a degree and should demonstrate that his or her experience is relevant for the position that is offered. And third, the salary of this applicant should not be less than 3,300 Singapore dollar per month, which is equivalent to 2,100 US dollar. Considering that this salary should always be in line with the level of responsibilities. So in other words, if you are hired to be a CEO and you are offered salary which is too low for the standard of the profession, then you may face difficulties to get your visa granted. An employment pass is usually granted for a period of 1 to 2 years and is renewable as far as the individual is employed in Singapore. The time frame to get the work permit is approximately 1 to 2 months from the date that all the supporting documents are submitted. The other type of visa scheme I'd like to talk to you about is the Entrepreneur Pass, which is dedicated to owners of newly incorporated or to be incorporated businesses who wish to operate their business from Singapore. If you wish to get an Entrepreneur Pass before registering a company, you should keep in mind that there are numerous eligibility criteria, such as, for instance, the registered capital, which should be no less than 50,000 Singapore dollar. You should also demonstrate that you have the relevant entrepreneurial background. You should be sponsored by another Singapore company, and you should fulfill at least one of the so-called innovativeness condition, meaning that you are sponsored by an accredited Singapore government agency or you have a collaboration agreement with an institution recognized by the Agency for Science and Technology of Singapore. As an additional supporting document, you will also be required to prepare a business plan providing further insights on your business projects in terms of marketing plan, market analysis, operational plan, or financial projections. The time frame is the same as for the work permit. Is 1 to 2 months from the date of completion of the application, which means the date when all supporting documents have been provided to the immigration department. Regarding the permanent residency, if you are an investor, you can apply for permanent residency, assuming that you invest at least 2.5 million Singapore dollar in some of the qualifying categories. If you are an employment pass holder, then you should be able to provide at least 6 months of Singapore salary slips, considering that the immigration will also review factors such as your educational background, your employment background, your salary, your financial assets, the donation that you've done to a charity organization, or your length of stay in Singapore, and all this to ensure that, of course, you will be an asset to Singapore. Next slide, please. All right. So even though Hong Kong and Singapore are places where it's relatively easy to get a work or investor visa when compared to jurisdiction like United States, where it's extremely hard. The Singapore Immigration Department is, from our experience, more time efficient and provide clearer guidelines when it comes to reviewing visa application. Next slide, please.
Yeah, our final battleground for today will be the exit from the market. What is actually necessary to retreat from either Hong Kong or Singapore? In Hong Kong, you have two options. There is the deregistration, which is the final closing of the company, and there is dormancy, which is a state of minimal compliance where the company can be reactivated very easily and which can be used flexibly to temporarily shut down a company and use it later again should it be advantageous again. For both procedures, the company needs to have no current ongoing business and has to have an audit not older than 1 year and current management accounts showing that the business truly is not active anymore. The company then needs to get the confirmation from the Inland Revenue Department that there is no outstanding tax liability and that the bank account has to be closed. Finally, the company's registry has to approve the deregistration or dormancy. In case of deregistration, it takes on average 9 to 12 months. A dormancy is a lot quicker and can be done in mere days or few weeks, but a company has to maintain the registered office address, company secretary, and at least one director and shareholder. However, a dormant company does not have to prepare any audits and does not have to file profit tax returns unless it is specifically requested by the Inland Revenue Department, which can happen every few years. The main advantage of a dormant company is that you can reactivate it in no time, basically. You can just start doing business again, have to open a new bank account, of course, but generally it allows for much more flexibility. And it allows you also to react to sudden market changes. Next slide, please.
All right. So exiting the market in Singapore. Under Singapore, law companies can be liquidated either by striking off or winding up. Striking off a company is generally a faster, easier, and cheaper option if you want to exit the market. That being said, there are also eligibility criteria to fulfill if you want to choose the strike-off. So I listed on this slide the main criteria. So the company must have ceased trading. The company must not be involved in any court proceedings, whether inside or outside Singapore. The company must have no assets and liabilities at the time of making the application. And the company must not be indebted to any government department. Once you've met all the conditions listed, then you will need to apply and receive approvals from the company's registry as well as from the Singapore Tax Department. The procedure takes about 5 to 6 months, and any individual or company who wishes to object the striking off can do so during this time frame until the final strike-off notification is issued. The second option you have to exit the market is the winding up. And well, this alternative is relatively more complicated, but you can choose, again, two routes. So the first route is the so-called voluntary winding up, which is engaged by the member and all the creditors of the company. A company may decide to wind up its affairs voluntarily if the directors believe that the company will be able to pay its debts in full within 12 months after the commencement of the winding up. Here again, there will be two options available: either the voluntary winding up, which is executed by the directors or shareholders. It's called the members' voluntary winding up, or an external liquidator can be also appointed to do the winding up. It's called the creditors' voluntary winding up. The second option for the winding up is called the compulsory winding up. In fact, it's not really an option because it's made under the order of the courts. So the company itself, its creditors, shareholders, the creditor or judicial manager may initiate liquidation proceedings with the High Court. the courts may appoint a liquidator to wind up the affairs of the company. Where no liquidator is appointed by the courts, then the official receiver shall be the liquidator of the company. After all the assets of the company has been assessed and realized, then the liquidator will adjudicate all the claims lodged against the company and admit or reject them accordingly. Any surplus after paying the creditors and cost of liquidation will be returned to the shareholders afterwards. Next slide, please.
Concluding our sixth and final battle, we believe Hong Kong and Singapore to be fairly equal, even though the advantages are very different. Hong Kong offers more flexibility for market exit with the option of dormancy, while a complete close down of a company can be achieved in Singapore in half the time than in Hong Kong. The requisites for liquidation are pretty much the same in both jurisdictions, so it comes down to the individual decision of each company which market exit is more beneficial to them. Next slide, please.
Alright, so on this table you can see the result of this battle. So in round one it was a draw. Basically, in terms of incorporations, Hong Kong seems easier because you don't need to appoint a local resident director. However, Singapore has the advantage in terms of ease of opening up a bank account. Then in terms of accounting and audit obligation, which was our round two, we elected Singapore as at the first place due to a more flexible system, in particular for startups and small and medium-sized enterprises. On round three, which is the tax regime, Hong Kong is going on the first place, given the possibility that qualifying entrepreneurs or companies have to apply for profits tax exemption. And then on round four, we appointed Hong Kong as the first place for, in terms of the other annual compliance obligation. Basically, there are less compliance obligation than in Hong Kong. So from a company's management perspective, Hong Kong is a bit better than Singapore. Then on round five, immigration, we decided that Singapore was at the first place. Primarily because, well, like I explained earlier, the Singapore Immigration Department provides more guidelines in terms of the visa schemes and process the visa application in a shorter time frame. And then finally exiting the market, then we decided it was a draw, well, mainly because the options are quite similar, even though Hong Kong can offer the possibility, as Dennis explained, to apply for dormancy. Next slide, please.
Yeah, finally, we want to do a bonus round, which is basically our general recommendations. While our results of the previous rounds might, in the end up in a draw, this does not mean at all that you can choose either and will be just as well off. It is not a flip of the coin. You should consider many factors before you make your final decision, and very similar to real estate, the main reason for most companies to go in either jurisdiction will be location, location, location. Where is your market? Where are your suppliers? Is your focus more on East Asia, like China and Taiwan, or is it rather the more and more developing Asian country region, for which Singapore is better? Do you need a physical presence in the market, and do you need employees on the ground? Based on these factors, you can also make a very different decision. And these are just a few questions anyone should ask themselves when assessing if Singapore or Hong Kong is better. Generally, if you're currently considering either jurisdiction for your business, I would just want to say, please feel free to get in touch with us, and we will gladly give you our perspective for each respective case, and we'll help you to determine which market is more viable for the goals you have. Next slide, please.
Dennis, Pierre, thank you very much for the presentation today. There have been a series of questions that have come in, and I've put them in order of the rounds that you created in terms of the battle between Hong Kong and Singapore. Now, a lot of the questions seem to reflect on what are your perceptions of what the future might bring to Hong Kong or Singapore. So the first question is in relation to Hong Kong, and what are your opinions in relation to whether Hong Kong will implement local resident directors as Singapore has?
Thank you, Christina. I don't think it is very likely at the moment that Hong Kong will implement local resident directors as a requirement. Simply because with a more and more transparent world that we're going to get more and more of in the coming years in terms of transparency of companies, there is just no need for this local resident director. And also the Hong Kong government is of course aware that many Hong Kong companies' reasoning is based on having the option to get money out of China, facilitate trade with China, mainly as a gateway to China, like you also explained in your presentation on Monday. So for these businesses, often there's no need to have local employees on the ground and having a physical presence. Of course, I encourage everyone, if you are interested in it, please do not hesitate. Hong Kong is a great place to open a physical business and actually doing business in the market, but I don't see it becoming compulsory anytime soon.
And you mentioned that in Hong Kong the situation with the bank account opening has well literally become a little bit of a nightmare, and we all know that questions coming in from clients are can a Hong Kong company open bank accounts in other jurisdictions, and then vice versa? Can Singapore also, a Singapore company, can it open bank accounts in other jurisdictions? And if the answer is yes, what would be the benefits for companies, if any?
Well, first off, absolutely. A Hong Kong company can open a bank account anywhere in the world. You just have to find a bank that is willing to do that, which is not often easy. But generally speaking, if you have a good relationship with your bank at home, then it is a good option to consider, and just ask them if they would be willing to open a bank account for a Hong Kong company. Generally speaking, there is no disadvantage to it, and there's no real advantage except for that you have the bank close to your real business if you do not go physically into Hong Kong. But if you go physically into Hong Kong, you will have almost never any problems with bank accounts here.
There are actually Hong Kong companies that today, in order to circumvent the current difficulties with bank account opening in Hong Kong, are going to Singapore banks and apply for bank accounts. The point is, when a Hong Kong business owner is applying for a Singapore bank account, then they should also provide the reasons why he wants to open a bank account. And what I mean is that he should provide like legitimate reasons to the bank officer, and legitimate reasons might be well, that potentially you have suppliers or customers who are located in Singapore, and for that reason you need a Singapore bank account. So there are ways to argue. Obviously, given the current situation in Hong Kong, I think the first route to observe or to try to see is trying to open a bank account in Hong Kong. Then if it's not possible, then you can envisage to inquire Singapore banks or even banks from Macau. In terms of Singapore, well, there can be actually a tax advantage to have an account overseas for a Singapore registered company, because as I explained earlier in the tax section, foreign source income which is not brought physically to Singapore is potentially not taxable. So there can be here a big advantage from a tax perspective.
Thank you. The next question is in relation to Hong Kong's tax exemption policy. Clients in general always make the mix-up when they approach us in relation to saying, I would like to set up an offshore company. Perhaps you could just delve into the procedures of what a tax exemption application really means and the difficulties that exist during a tax exemption application for the audience.
Sure. So when a company applies offshore tax exemption, they do it by submitting the profit tax return as normally to the IRD every year, and then they state that their income has no relation to Hong Kong. It does not touch, the products do not touch Hong Kong. There are no employees on the ground, and the profit does not derive from any business done in Hong Kong. And submit this to the IRD. So the first difficulty or the first downside to this is that the IRD will of course look at cases that are most interesting to them first. So if your business is not in a range where the turnover is significant, then it might happen that you have to wait quite a while for the IRD to even assess your application. The positive note, until your application is either granted or refused, you're in any case provisionally exempted from tax. But profit tax exemption application on average takes around 3 years. And during that time, the IRD will look at certain transactions and ask you for more details, and will look in detail into your finances, what has happened during the year. Is there really nothing that has any connection to Hong Kong? Was there any shipping document that says an import into Hong Kong? Anything like this. So it is a very lengthy procedure with a lot of communication with the IRD. And ideally you want to have someone on your side, like a corporate service provider like us, who guides you through the process, because it's really one of the more complicated things you can do in terms of a Hong Kong company, maintaining a Hong Kong company.
Just to add on to what Dennis has said, a lot of the misperceptions about offshore tax exemption in Hong Kong is related to the fact that many companies have the assumption that once they've gone through one tax exemption application, they are tax exempted for life. And actually, when Dennis mentioned that a tax exemption application takes 3 years, it takes 3 years for that specific fiscal year. And it's then 3 years for every additional fiscal year you have to make that tax exemption application. The reason behind that is that obviously, like any other jurisdiction in the world, the Inland Revenue Department wants money. They want tax dollars. So they're obviously not going to make the process as simple as what people perceive it to be. And I just want that to be clarified to all the attendees that are online today.
Absolutely correct.
How do you both defend the contradiction currently in Hong Kong in relation to the fact that to open bank accounts, the banks are requiring to see substance of a Hong Kong company, and yet to declare tax exemption, you need to have an offshore non-substance related entity?
You mean how do we defend that from which point of view?
To the clients that are looking to set up entities in Hong Kong that would perhaps be able to apply for tax exemption, but bank accounts are not yet opened.
Generally speaking, I would say currently it's a big contradiction. Of course, one of the big advantages of Hong Kong is to apply offshore tax exemption, yet you are not very likely getting a bank account without having any substance currently. That being said, of course, case by case, so you might not actually have any problem. But there are still some I don't want to say structures, but some business models where it is still possible to use the offshore tax exemption. For example, if you use Hong Kong as a point of sourcing for your Chinese company or for your overseas company to facilitate that trade. You don't really need any substance in Hong Kong, and yet it's a very physical business, which is much liked by the banks. But the main point remains, you have to pay taxes somewhere. You can apply the offshore tax exemption in Hong Kong, but that does not mean that you're tax exempted everywhere in the world.
Yeah, ultimately, I think there is also one point to consider for every future investors who want to set up a company in Hong Kong and apply tax exemption is to know whether the bank overseas can support them in Hong Kong. We have many clients who approach us, and we sometimes discuss with them which bank, in terms of which bank they are using overseas. And then we discover at some point that these banks have a branch office in Hong Kong. When we are in this kind of scenario, then the due diligence of the bank has been already performed by the jurisdiction, by the branch where the client is originated from. So in that case, it is likely that the bank account opening procedure in Hong Kong will be made much easier, and the client will not have to actually rent an office space or employ local staff, and then ultimately, well, it will be also qualifying for applying to the tax exemption. So it's really, I think, what investors should ask themselves before coming to Hong Kong is, can my bank, whether they are located in Europe or in the United States or wherever in the world, does my bank have a branch office in Hong Kong? Are they willing to support me with this project in Hong Kong? I think that's one of the big questions that they can ask themselves as well.
In relation to the round on annual compliance obligations, a comment was made in relation to clients paying less attention to those types of details, which obviously in any jurisdiction there's always going to be annual compliance obligations that need to occur. And it was mentioned that penalties could arise. Now, in China, if there is a lack of ignorance on annual compliance obligations, ultimately companies in China can become blacklisted, and the chief or legal representatives of those companies can be put on the blacklist as well in terms of no longer entry into China. What are the repercussions in Hong Kong as well as in Singapore if there is a lack of filing of these annual compliance obligations? What are worst case scenarios?
Well, usually what can happen basically when an entrepreneur, when a company fails to comply with its annual obligations, then usually both in Singapore and Hong Kong there are certain level of penalties that are issued. For instance, if you fail complying or if you fail providing your updated annual return, then you will have a penalty which will be repeated at different frequency as long as you do not fulfill these requirements. And then after some points, there might be also court summons which can be sent to the entrepreneurs, where shareholders or directors or any representative have to go to the courts and explain why they failed to comply with the requirements. Then the worst case scenario that can happen is that, well, basically if a company fails to renew its business license for Hong Kong or to renew its annual return or file its AGM, then basically the companies registering in each jurisdiction can decide to basically strike off the company for lack of compliance. That's the worst case scenario that can happen.
Understood. In relation to immigration, one of the attendees was unable to hear clearly from Dennis the number of years it takes an individual to become a permanent resident in Hong Kong. Could you just reiterate that, Dennis?
Sure. For valid visa holders, it takes 7 consecutive years under any valid visa scheme that allows employment in Hong Kong.
Thank you. In relation to the last round about exiting the market, each of you provided two different types of liquidating options or exit options. Could you just highlight what you see as the common trends that companies are doing when business slows, when the market slows? What options are they choosing in terms of each jurisdiction?
Well, in Hong Kong, it's very different from business to business, depending on what they were actually doing before. We still have some clients that prefer the dormancy over the closing down of the company for multiple reasons. For example, if they plan on doing anything in the future here in Hong Kong, or generally in Asia actually, they oftentimes put the company dormant so that they can use it more easily and don't go through the entire setup procedure again at a later stage. Also, the dormancy is used to close the gap basically when you want to close a company but have an open offshore tax exemption. So if you have to wait, for example, 2 more years for your offshore tax exemption and you're very positive that it's going to be granted, you can make your company dormant, wait for the offshore tax exemption to be granted, and then close down the company. So it can also be an intermediary step. And of course, the closing down in Hong Kong, there's only one option. So,
well, clearly for Singapore, I mean, the strike-off is usually the main way of exiting the market, mainly because from a cost and time point of view, I mean, it's really the most efficient kind of solution. Now, it can happen also that bigger companies which are really in great financial difficulties also choose a wind-up solution, but that's I would say for the client that we are working with, it's not a very common way to exit the markets. Then one thing that actually we did not mention but we can observe from time to time is also entrepreneurs, foreign entrepreneurs owning either a Hong Kong or a Singapore company, and who decide actually to sell, who sees that company as a real asset with a real value, of course, and decide to sell either to a competitor or to sometimes to an employee. They decide to sell their companies to a third party. That can, I think, for foreign entrepreneurs, that can also be an option, especially if you consider, at least for Hong Kong, the difficulty of opening a bank account. Nowadays, a Hong Kong company which has an operating bank account is definitely an asset, or at least has a certain value, right? Now, if an entrepreneur wants to exit the market, you can also consider to sell this company to a third party. And of course, if he wants to do so, he should, same as if he wants to strike off, he should also ensure that the company is aligning with all the requirements in terms of audit, in terms of accounting, or etc. before actually selling the company to a third party. So that can also be another option that we did not mention.
Well, that's the end of today's questions. I'd like to thank Pierre and Dennis for presenting today on Hong Kong versus Singapore. If any of the attendees have any further questions, then please don't hesitate to contact Pierre or Dennis directly. They'd be happy to advise you and direct you in terms of what are the trends that are occurring, or the difficulties as well as the positives that are occurring in the market. This is the final webinar session of our Hong Kong versus Singapore webinar series. I hope that you all enjoyed it, and if you are interested in subscribing to our further marketing materials, resources, and webinars, it can be easily done so on our website. And please do follow us on YouTube and LinkedIn if you'd like to hear more about what Kohler Group is offering. So again, thank you all. Have a lovely weekend, and I wish you all the best. Goodbye.